Hello, Professor. Myself, Abdul Samad Ansari, and the topic of our presentation today is the case of Bank of Montreal versus DUGID. So these are our teammates and their student IDs. So as you can see, we have this is our content organization, which includes facts, issues, holdings, and rationales. And moving on to the introduction and name of the parties. So this case have only two parties, which is Bank of Montreal and Dugid. There were no appearances except these two, and this case was heard on the year 2000. It was the case between two parties in which Bank of Montreal was the plaintiff and Dugid was the defendant. So I will give you a small introduction about this case. So in this case, the Bank of Montreal and Dugid was decided by a court of appeal for Ontario is about whether a guarantee signed by Dugid could be enforced. The Bank of Montreal gave a loan to someone else and Dugid guaranteed it. When the loan wasn't repaid, BMO asked Duguid to pay and argued that BMO didn't tell him the important facts about the borrower's financial problems when he signed the guarantee. The case focuses on whether BMO had a duty to share that information or not. So, moving on to a brief introduction for this case study. So, in this case, the Bank of Montreal BMO sought to enforce a guarantee signed by Dugid for a loan given to a third party who later defaulted. Dugid argued that the guarantee was invalid because BMO failed to disclose important financial information about the borrower. The trial court ruled in favor of Dugid, finding that BMO's non-disclosure made the guarantee unforeseeable. On appeal, the Court of Appeal reviewed whether BMO had a legal duty to disclose such information to Dugid or not. So, next slide will be presented by my next team members. Thank you.
Hello everyone, my name is Simranjit Singh. I'm second member of this group and I will continue the further topics for this presentation. This is factual and procedural events leading to judgment. So, Duke signed a guarantee for a loan that was given by the Bank of Montreal to a third party business. The purpose of the guarantee was to secure the loan, meaning that Duke would be responsible if the business failed to repay it. Unfortunately, the business didn't default on the loan, they didn't pay it back. As a result, BMO went over Duguid to collect the outstanding debt, holding him responsible because of the guarantee he had signed. Now, here where things get interesting. Duguid argued that BMO hadn't been fully transparent with him before he signed the guarantee. He claimed that the bank didn't disclose important information about the financial status of the business. Especially, Lugit said BMO didn't provide accurate, complete details about the debtor's financial condition, which was which would have impacted his decision to sign guarantee in the first place. So Duke's defense was that bank failure to disclose this information was misleading, and because of that, he shouldn't been held liable for the debt. The bank, on the other hand, argued that they had no legal obligation to provide such information to Dugin. They contended that the trial court had made a mistake by siding with the Dugin and they should be entitled to enforce the guarantee. After reviewing the case, the Court of Appeal sided with Dugin. They agreed with the trial court ruling, confirming that BMO did have a duty to disclose material information to Dugin before he signed the guarantee. The court found that the bank's failure to do so was a key factor, and they dismissed the appeal. As a result, Duguid was not required to pay the debt under the guarantee. In the end, the case reinforces the importance of transparency and disclosure when it comes to guarantee. Creditors like banks may owe certain duties to guarantors, especially when the guarantor is at a risk of being held liable for a debt they may not have fully understood. So this was all about the factual and procedural events leading to the judgment. and other topics will be continued by my next group member.
So, hello, Professor. Myself, Johnny Kumar. Today, me and my team members are discussing the case of Bank of Montreal versus Dugid 2000, in which the Bank of Montreal is plaintiff and the Dugid is defendant. And now I'm gonna shed some lights on issues related to this case. So, in Bank of Montreal versus Dugid 2000, the central issue under consideration is whether the Bank of Montreal had a duty to disclose material information about the primary debator's financial status to Dugit, who signed a guarantee for the loan. Dugid contested the enforceability of the guarantee on the grounds that Bank of Montreal failed to provide him with key financial information regarding the debater at the time he signed the guarantee. So, in Bank of Montreal versus Dugit 2000, the main issue was for whether the Bank of Montreal had a responsibility to share important financial information about the primary borrower with Dugit. Who had agreed to guarantee the loan. Dugid argued that if he had known the true financial situation of the borrower, he would not have signed the guarantee. So the case ultimately examined whether a creditor has an obligation to disclose information to a guarantor, and if a failure to do so affects the validity of the guarantee. The court also considered whether Bank of Montreal's conduct constituted a misrepresentation that rendered the guarantee unforeseeable. So, on the next slide, I'm gonna shed some lights on holdings related to this case. Uh, so I researched in this case and found that the court had to decide if the bank was obligated to give Dugit this information, and if failing to do so, made the guarantee invalid. Additionally, the court considered whether Bank of Montreal actions could be seen as a misrepresentation that would make the guarantee unforeseeable. Now, in holding session, in the case of Bank of Montreal versus Dugit 2000, the court had to the Court of Appeal of Ontario upheld the decision of trial court, and the Ontario Court of Appeal agreed with the trial court, ruling in favor of Dugit and concluded that Bank of Montreal did have a duty to disclose the debater's financial conditions as well. So the key legal issue was whether the Bank of Montreal had a duty to disclose material information about the primary financial status to Dugid before he signed the agreement. So that's all about my part. So next part will be covered by my next team member. Thank you so much.
Hello, Professor. My name is Aman, and today I would like to talk about the applied rule of law, which is used in this case, in which the court applied fundamental principle of contract law and equity, placing particular emphasis on the obligation of creator to provide the full disclosure of reveal and the material fact to grantor. It held that creators such as BMO are required to fulfill a duty of transparency, especially in situations where a grantor is at risk of being held liable for the financial obligation of a third party. This duty ensure that grantor have all necessary information to make to make to make informed decision regarding uh, their potential liability. And my second slide about the decision which is made by The court the Court of Appeal ruled that BMO had a duty to disclose the financial condition of a debtor as this information was relevant to the decision to sign the guarantee. Since BMO failed to disclose this critical information, the court concluded that the guarantee was unenforceable. The court affirmed the trial decision and the appeal by BMO was dismissed. The court decision reinforced the idea that grantor must be fully informed of all material fact affecting their financial obligation, and failure to disclose such information could render the guarantee void. Thank you. This is my part, and the next slide will continue by my teammate. Thank you.
Hello everyone, my name is Harmanpreet and my student ID is 4386602, and now I'm going to talk about the rationale of this case. So the Court of Appeal in Bank of Montreal reached its decision based on several key logical principles and considerations. Uh, the reason behind the court's holding focus on the duties of deceased owned by the creditors to guarantee the implication of non-disclosure. So, firstly, the duty of disclosure to guarantors. The court emphasized that creditors owe a duty of disclosure to guarantors when the guarantor is assuming financial responsibility for the debt of a third party. This duty is grounded in equity and the principles of good faith in contractual relationships. The rationale is that a guarantor should not be held liable for a debt unless they have been fully informed about the risks they are undertaking. Nextly, the material information. So the court found that the financial condition of the primary debtor was material information that BMO should have disclosed to DUGUID. A guarantor needs to understand the likelihood of the debtor's default as they directly affect the guarantor's exposure to financial liability. In this case, BMO's failure to disclose the doctor's financial situation was seen as a form of misrepresentation by omission. The court considered this non-disclosure as a lack of good faith in the relationship between BMO and DUGUID, who was at risk of being called upon to pay the debt. Lastly, the legal precedents and contractual fairness. The court relied on precedents in contractual law and equity that emphasize fairness and transparency in agreements involving guarantors. A guarantor is generally viewed as a vulnerable party as they are assuming responsibility for another person's debt as without having the same level of control or information about the primary debtor's financial situation. The court also referred to the broader principle that contracts entered into without full disclosure of material facts are potentially unenforceable, particularly when one party, the guarantor, is placed significantly risk. So next will be discussed by Poonam. Thank you.
Another is that material information and BMO omission. The financial condition of primary debitors is considered essential information that must be shared with our guarantors. In the case of BMO failed to disclose the debitor's poor financial state, which was a crucial for a guider to properly assess the risk he was taking on. Second is that the court viewed the omission as breach of good faith and transparency, amounting to a mispresentation by failing to provide a critical fact. And other part is that fairness in guarantee contracts. Guarantors are often in vulnerable position because they rely on creditor to provide accurate and complete information about the debitor. Without this, they cannot make informed decisions. The court reinforced that contracts involving guarantors must be fair and transparent. If creditor withholds material information and guarantee may become enforceable due to unfairness or lack of informed consent from the guarantors. To conclude it, BMO not disclosure for debaters. Financial situation was unfair to DUGUID. The court ruled that creditors have clear duty to inform grantors of all critical, ensuring fairness and equality in grantors' agreement.
So moving on to the conclusion of the case, in Bank of Montreal versus Duguid case, the Court of Appeal for Ontario upheld the trial court's decision affirming that the Bank of Montreal was obligated to disclose material information about the financial conditions of the primary debtor of Duguid, the guarantor. The court found that the BMO's failure to disclose this information constituted misrepresentation by omission, rendering the guarantee unforeseeable. This case underscores the importance of transparency and fairness in contractual relationships, particularly where one party, the guarantor, assumes significant financial risk based on the actions of another. The ruling reinforces the legal duty of creditors to act in good faith and provide all materials facts to guarantors before they undertake financial responsibility. Thank you and have a nice day.